Well, the automatic stay is triggered by the filing of any bankruptcy case. It doesn't really matter what chapter it is. So yes, wage garnishment can be terminated. Now, of course, we're talking about a personal bankruptcy here. A corporation that files for bankruptcy is typically not having its checks garnished because it doesn't get paychecks. But in a personal bankruptcy, regardless of chapter under which you file, the automatic stay is triggered and it will stop the wage garnishment. Now, this can be a temporary bit of relief, and there are a couple of contexts in which this plays out. The first is in dealing with a limitation on the automatic stay. In 2005, Congress passed, it's called BAPCPA, Bankruptcy Abuse Prevention and Consumer Protection Act. In that act, there was an abuse that was corrected. What was this abuse? Well, prior to that, this typically happened in a Chapter 13 bankruptcy. There's a couple in a house, they're facing a foreclosure sale. Husband files a Chapter 13. The reason he files the 13 is because creditors are less likely to take action since there is the possibility that they're going to get paid through a Chapter 13 plan. But the husband doesn't file a complete set of bankruptcy papers. Instead, he files what we refer to as a face sheet filing, just enough to trigger the automatic stay. Takes no action to cure the filing deficiency, so 45 days later, the court dismisses the case for failure to prosecute. Foreclosure sale is about ready to restart. Wife files a Chapter 13. That triggers the automatic stay again, stops the foreclosure sale. She also files a face sheet filing. Takes no action to cure the filing deficiency. 45 days later, the court dismisses the case. Foreclosure sale is about ready to happen again. Husband files. Triggers the automatic stay again. And so what they're doing is tag teaming each other to push off the idea of having a foreclosure sale. Well, the creditors had had just about enough of that, so they lobbied Congress very hard and they got the law changed. Now, the way the law is written, if you have had a bankruptcy case pending during the 12 months prior to the filing of the current bankruptcy case, the automatic stay terminates on day 30 unless, prior to that, you can get the judge assigned to this new bankruptcy case to enter an order reinstating the stay. And you're going to have to establish that you have been filing in good faith. This isn't just a mechanical thing where you file a paper and the judge signs off on it. If you've had more than one bankruptcy case pending during the prior 12 months, then there is no automatic stay. So in that situation, the wage garnishment could continue. Now, you might take umbrage and go to the court and say, this creditor has violated the automatic stay, but the creditor will point out that because of these two prior bankruptcy cases during the previous 12 months, there is no automatic stay, and the creditor will probably win. So, yes, the automatic stay is triggered in any bankruptcy case, and it will stop a wage garnishment. But if you have had prior bankruptcy cases pending during the 12 months prior to filing the current case, then the automatic stay is not going to be there, and the wage garnishment will continue.